Okay, so good afternoon. I'd like to thank the Hillside Public Library for bringing me back again to talk about estate planning, which is a very important and can be interesting program. And I hope you'll find it informative and helpful to you in your personal estate planning path. My name is Zahava Schechter. You'll learn a little bit about me in a moment. I would just like to preface this program by saying I will not be providing specific legal advice to anyone. You're free to call me afterwards or to put, when the chat is enabled, to put comments or questions in the chat box, but I am not going to give specific legal information or advice, certainly not advice in this program. So let's get going. As you see, my office is in Westbury. And here we go. As I said, if you would like to call me or email me, feel free. I also do have, as I mentioned, a YouTube channel. I have a website. I've got a podcast. You'll hear more about that in a moment. I'm an attorney with more than 30 years of experience. Today, we're talking about estate planning, which is what we do while people are alive and have mental capacity. As we talk about being well and capacity, ability to understand things, we're talking mental, not physical. I also handle administration matters after someone dies, litigation when families don't get along and the lawyers win. So that's really not a good idea, as well as real estate conveyances and business law. I do have a podcast. If you like, it's a free podcast. If you like to know what's going on in the legal world on Long Island, you may be interested in my podcast, the LI Law Podcast. And let's start. Before I actually go into estate planning, I just want to put up this website. If you're not familiar with this website, may I recommend that you go to the New York State Office of Unclaimed Funds and see if there is any lost money waiting for you or your family. There is no fee to claim money which has been lost, misplaced, not found. Maybe your name is misspelled. I don't know. But every time I get a new client, I look for funds. This week alone, I've already found for 3 new clients funds. So why would New York State be holding money? Maybe because your address has changed and the bank or the brokerage institution or the insurance company doesn't know your new address. Maybe because there's been a merger and that information is not passed on to the new institution. In any case, it is a very worthwhile thing to do, and happy hunting. I hope you find money, because certainly New York State is holding many billions of dollars that belong to New York State residents. So let's get right into our program. This is going to be a basic discussion of estate planning. There's so much we can talk about, but this is just the beginning. So let's talk about nothing fancy, the basic estate planning that every adult 18 years and older, which is the age of majority, 18 in New York State, every adult should have. And I first want to start by talking about what estate planning is. So you are planning for an estate. A lot of people think that an estate is involved while you are still alive. That is not correct. So for example, to say the estate of Zahava Schechter is wrong because I'm still alive. An estate is only applicable to someone who has died. So if you take a picture, a photo at the time someone dies, and you see all of their assets, all of their liabilities, that is their estate. So we are planning for what happens in case of death or incapacity. And there are 3 basic documents: healthcare proxy, durable power of attorney, and last will and testament. We're going to go into each of them in a bit more detail, but I will tell you now, the first 2 documents, the healthcare proxy and the power of attorney, are valid and deal with issues while you are alive. The last document, the last will and testament, is only effective when you die. Why am I telling you this? Because people call me and say, oh, I want to make a will. And I say to them, oh, are you dying imminently? Because if you are not dying today, tomorrow, or the next day, you need a healthcare proxy and a power of attorney to deal with the next 20, 30, 50 years of your life, however long it is, to deal with issues while you're alive. You can make a will today, tomorrow, the next day. They're all valid, but the only one that is effective is the last one you make. So as a result, until you die, that document is kind of sitting in limbo and has no effect. make sure that if you are doing estate planning, that you have all of these 3 basic documents. We will talk about trust and other things a little bit later on and briefly, but this is what people need. So I like to inject a little humor into my presentations. I hope you don't mind. So Mr. Frosty, it's March. He's going to be melting soon. Time to talk estate planning. Thank you, Stu. So let's start with healthcare proxy. By the way, I hope you all have an attachment, which I sent to the library, and you could work on for your own plan if you don't have a healthcare proxy yet. It is not a legally binding document by any means, but it's something that will help you to think about what your wishes might be. So the healthcare proxy applies to healthcare decisions. So let's start with that. Healthcare decisions. Do you want to go to Northwell or to Winthrop or to any other hospital? Do you want a procedure? Do you not want the procedure? Do you want a medication? What are your healthcare and end-of-life wishes? That's it. It's not about money. It's not about insurance. It's not about Medicare. It's not about a lot of things. It's only healthcare decisions, but it's important because the power of attorney, which we're going to get to next, does not deal with healthcare decisions. So this is a very important document on its own, and it is not redundant in any way when we get to the power of attorney. So again, applies to healthcare decisions, but only if you're unable to make your own decisions. So today, Marcia, I see you. So I hope you don't mind. I'm going to say Marcia is fine. Marcia knows who she is. Marcia knows which doctor she wants, if she wants a procedure, if she doesn't want that hospital. So even, I don't know if Marcia's married. I don't know if she has children. I don't know what the doctor says. Let's say everybody says, Marcia, you need this procedure. But Marcia says, no, I don't want that procedure. No one can make Marcia do it. And that applies to everybody, as long as you're 18 and over and have mental capacity, mental ability to understand. I'm explaining here briefly, but basically what is being said to you, and you're communicating what your wishes are. That's when the decision-making power comes into play. What happens if you don't have a healthcare proxy? The doctor makes the decision. That's right, the doctor. People say to me, oh, well, I'm married. My husband or my wife will make the decision, or my adult child. No, once you're 18, no one has the right to either get your records or make your decisions for you. That's under the HIPAA law, right? We're going to talk about HIPAA in a moment. The idea being that no one can force you to do something against your will for healthcare purposes, as long as you understand what is being communicated to you. So and can communicate outward. So it's very important to name agents, and we'll get to that in a moment. But I do want to talk about the HIPAA release. I don't know about you, but when I go even for a regular, well checkup, I get an explanation of benefits from my insurance company. I don't really understand all the things that are being billed to me. So one of the things that and also the charges aren't always correct. I don't know if that's your experience, that's my experience. So in the healthcare proxy, we can also allow our agents not only to make decisions for us, and I'm sorry, I didn't qualify. Agent is the name of the person whom we appoint, we nominate to make a decision if we are unable to do so. We allow that person also to get our records, to be able to speak to, I'm sorry, that's a dog. Sorry about that. To be able to speak to the billing department and to be able to negotiate bills. So that's very important. Otherwise, if you don't have a HIPAA release of information, no one can speak on your behalf, whether it's bills or records or anything else. Instructions to agent. DNR stands for do not resuscitate. So this is a very personal decision. If the doctor says that you do not have that is, let's put it this way, it is unlikely that you will be able to recover and not be from whatever is going on health-wise in your life, and not and not be in other than a vegetative state, meaning you will not recover the way you would want to, thinking, eating, able to manage your own affairs. Do you want to be kept alive? Now, some people do, and that's fine. There's no judgment here. What matters here is what you want. Do you want to be kept alive, or do you not want to be kept alive in those circumstances? It's very important to put that in the healthcare proxy. Organ donation. Very important issue. Some people believe in organ donation, or maybe they only want to donate some organs. Now, you may say to me, and by the way, if you don't want to donate organs, that's good too. Some people say, oh, I have that on my driver's license, or I have that on some other indication. Chances are in the hospital, they're not looking at your driver's license, but they will be looking at your healthcare proxy. So it's very important to put that in there. Burial or cremation instructions. There are people who feel very strongly, whether it's burial, cremation, maybe you have a plot already, maybe you have a funeral home you want to go to, especially if you are a religious person, whatever your religion is, maybe you have certain requests. Sometimes I have clients who say to me, you know, they're Catholic and they want certain hymns and they want a mass and they want this church and that church. If you're Jewish, and generally we're are buried the same day, you may want specific instructions there. This is a great place to put instructions. And one last thing I'm going to say, during COVID, or the height of COVID, I have a number of colleagues or associates who run or work in funeral homes. And they told me that the people who had in their healthcare proxies, the people who had burial or cremation instructions were put at the top of the list. If you recall, there were refrigerated trucks outside, et cetera. There was just such a large number of people who were dying that it was just overwhelming for the funeral homes. The fact that some people had healthcare proxies, which stated specifically what they wanted, named an agent who could take care of all that for them, put them to the top of the list. So I strongly suggest to you that you consider that in your healthcare proxy. Now we get to what is probably the most important thing in a healthcare proxy, which is selection of your agent. And then we're going to talk about the successor agent in a moment. But the agent is important. Why? Let's say I have in my proxy, keep alive at all costs. Does my agent have to comply with that? The answer is no. The agent is given a guidance in the healthcare proxy, what you would like to do. But the agent in the end makes the decision. So make sure that your agent is someone who knows what your requests are, what you would do if you were able to communicate your wishes, because that's the person who's going to make the final decision. So for example, I have clients, husband and wife, who the husband wants to be cremated. The wife does not want to cremate him. So I said to the husband, in the presence of the wife, you may want a different agent. You don't have to name your spouse, but just know that your wife is saying she will not cremate you. So if you name her as agent, you're going to be buried. So I'm just saying the choice of agent is really important, and you must have at least one successor agent, at least once a week. I see someone's documents, they ask me to review them, and I see there's no agent, backup agent. So you name Zahava Schechter, and then Zahava Schechter dies, isn't available, isn't willing, moves out of the country, whatever. You don't have a backup. So that was a total waste of a document. You must have at least one successor agent. I actually prefer a backup to the successor called an alternate. And one more thing I want to say. Sometimes people come to me and say, oh, I've got 3 adult children and I want them all to be the agents. And I try to talk them out of it. Usually I'm successful, but not always. Why? Because if you name more than one person, whether it's 2, 3, however many, they all have to be available. They all have to agree. What if they don't agree? Then nothing can get done. They all have to be able and willing to move forward. If anyone stops or says, I don't know, I don't agree, nothing can get done. Please do yourself a favor. Name one agent, name one successor agent, and one alternate successor. I think the best thing you could do. Okay, so I gave you a form. Hopefully you have it. If not, you can work along with me with my presentation. So here are some factors to consider when you're considering whom would you name as an agent. Proximity. Is it somebody here in New York or somebody in California or in Europe or wherever? I'm not telling you that the best person is someone local, but that is easier. It's easier for someone to come in to see you or to deal with the doctor or the hospital. Just keep that in mind. Age and health of candidates. So before COVID, I would say to you, pick someone relatively younger. Younger now is a relative thing. 50s, 60s is considered young. However, we know from COVID, people die of all ages. So I would just say to you that try to consider someone's health in general. Obviously, someone who is not well may not be able to help you. And then certainly you need a backup to that person. Willingness to act. So it's happened that I see healthcare proxies all the time. And you name Zahava Schechter as agent, and Zahava Schechter doesn't even know about it. You don't even have to tell her about it. You don't. And then when the time comes and you're not able to make your own decisions, Zahava Schechter says, no, I don't want to do it. Also, waste of a document, really bad decision. Talk to your agents. A lot of people say, oh, it's a hard decision. So I will tell you, my mother died, wow, I think 8 years ago at this point. And I had a long conversation with my mother. She died in her 90s, but I had a long conversation when she was even in her 70s about, Mom, let's start doing planning. And it's very important that, especially if you have children, if you don't have children, if you don't have a spouse, it's urgent, because then you're asking friends or extended family. But even with a spouse and friends and children, you need to make sure that these people whom you want to name are willing to do it. And if they're not, that's okay. Name someone else. Ability to handle difficult decisions. We're going to talk about the power of attorney in a minute, which deals with more than a minute, which deals with money and records, etc. That's not really what we're talking about here. We're talking about ability, emotional ability to handle tough decisions, life and death decisions. And I want to say one other thing here, if I may, which is in New York State, there is no right to die. What do I mean by that? Within the last few years, the Court of Appeals, which is the highest court, basically said, and it reaffirmed, meaning that had been the law and it agreed, you can't help someone die. You can't, you can't assist them to kill themselves, basically. So we're making decisions which could affect life or death. The issue with resuscitation and plugging someone into a respirator is not so much plugging someone in. That's not the issue. Because if you're not plugged in and you die, if you believe in God, you say it's from God, or however you think of it. The issue is once you plug someone into a respirator, if you unplug them, there's a greater chance that you are causing their death. So there's a lot of emotional, religious issues here. Make sure that your agent is someone who can handle that. Okay, who is your successor healthcare agent? And will agree to do so. You need these backups and the alternate. We discussed that. What are your end of life wishes? I have a client right now who wants to be cremated, and she wants her ashes spread in a certain location. As I mentioned to you, you could put in, if you're religious and you want a mass, or you want a certain type of service, or you want hymns, whatever it is you want. This is your ability. This is your time to say what you want. There is no cookie cutter document. This is what you want to happen, especially if you cannot communicate your wishes. And whether it's keep alive or do not resuscitate or something in the middle, that's up to you. Do you want to make an anatomical gift? I had a client who did not want to make a general gift, but because in her family, skin cancer was a big issue, she wanted to be able to donate, if it was needed, any skin on her body, but no other organs. Okay, that's fine. Whatever it is you want to do, that's what should be done. Do you have a cemetery plot prepaid? I do want to talk about pre-need planning. In New York State, we have the ability to go to a funeral home to pay, it's a program through the New York State Department of Insurance to prepay exactly what you want. If you want cremation, if you want burial, what kind of coffin, how you want things to go. It's certainly cheaper than waiting until the time comes and then who's going to pay for your funeral. And the money is kept not with the funeral home, but with New York State, and it accrues interest. So chances are when the time comes after however many years, not only will your next of kin not have to pay more, they may even get a refund check. But the point is, pre-need planning, again, I did that with my mother. Pre-need planning really helps those you leave behind, because when my mother died in the hospital, I made one phone call to the funeral home. This is the truth. One phone call, and everything was taken care of because we had already done all the planning. So I was able to deal with my own mourning and my grieving. It is a gift that we give people we leave behind. So please consider that if you're interested in doing so. Do you have specific instructions? I don't know, but this is the place to put it. And now we're going to move on from the healthcare proxy to the durable power of attorney. Oh, I'm so sorry. Okay. The power of attorney was revised June 13th, 2021. If you have a power of attorney from before then, I strongly suggest that you that you make a new power of attorney. There are many laws many changes affecting the power of attorney, and the documents are totally different. So I suggest you do that. Applies to financial matters. Again, not healthcare matters, not healthcare decisions, which hospital, which procedure, Medicare, Social Security, banks, insurance, anything other than healthcare. And it's valid if you later become incapacitated. That's the durable part. So today, Zahava Schechter is well mentally. God forbid tomorrow I'm in a coma or I have dementia or Alzheimer's or whatever it is, it's still good. As long as the document was made while I had mental capacity, we're good. Again, choose your agent and successor agent wisely. And I'm going to tell you why. Do you remember I said to you on the healthcare proxy that that document only comes into play if you are not able to understand and communicate your wishes? Not so on the power of attorney. Today, I give John my power under the power of attorney. He can go and empty, even if I'm well, I'm mentally well, I'm physically well, not that that matters, but he can go and empty all my bank accounts. He can sell my house. He can change my beneficiaries. It's a dangerous document, but extremely important, because once you don't have capacity, you can't make it. These are documents that you hold, we're going to talk about that later, in a fire safe in your house. You don't give them to the agent, but do them when you're well, because when they are needed, it's too late to make them. Okay, so think about who your agent is. Also, someone good with money, someone who can keep records, someone who is not going to, who's trustworthy, not going to take money from you. Unlike the healthcare proxy or the will, which we'll discuss later, in New York State, the agent must accept in writing. So if I'm naming John as agent, John is going to have to sign. And as I said, valid as soon as executed. Right away, John has that power. Okay, we're moving on to the last will and testament. Wow, look at the time. Unlike the healthcare proxy and the power of attorney, in which your agent is the fiduciary, the agent, that's what we call that person who has the power. In the will, that person's called an executor. If some of you know people in Florida, it's called a personal representative. Other states have other names, but in New York State, it's called the executor. Again, name one executor. This is just my suggestion. And then a backup successor executor, and even alternate. So what do you have in the last will and testament, which again is only valid after you die, and only the last one you made is valid, but after you die? You have all kinds of bequests, a specific bequest, a general. Is it money? Is it a watch? Is it a ring? Do you want to give money to charities? Do you want to give percentages? There is no cookie cutter will. It's what you want. Under New York State law, only people 18 years of age and older can make a will. There must be 2 disinterested witnesses. What does that mean? That means my husband, who's maybe named in the will, he is an interested witness, so he cannot be one of the 2 required witnesses. Basically, I have people as witnesses when I execute for clients, people who don't know the testator, that's the person who makes the will. It's none of their business what your wishes are. So it can't be anyone in your family, a son, a daughter, an in-law, no one who would have any kind of interest. It must be notarized. There are more laws, there are more rules, but there is definitely a procedure. It's not that you write it out yourself and you're done. There is a procedure. And if that procedure is not complied with, the court, which has jurisdiction, called the Surrogates Court, SURROGATE''S, Surrogates Court in New York State, which is the only court which can deal with deceased persons, and the court that has jurisdiction, meaning the court that can hear about your particular estate, in your case would be Nassau County. It's where you reside. Now, let's say you reside in Nassau most of the time, but you have a vacation home in California and one in Florida, and you die in the Florida home. Well, if you're still a New York State resident and you have a driver's license and a tax return and whatever, which lists all those documents, which list your address in Nassau County, then Nassau County has jurisdiction over your assets. There's so much more to discuss. I'm trying to do this briefly, but just know that you need to deal with the surrogate's court. Guardian. If any of you has minor children, it's very important to name who the backup person would be. Now, the court has the final decision-making power, but that's especially important with children, not grandchildren, but children under the age of 18. Finally, I briefly want to talk about a testamentary trust. We're going to talk about a trust a little later. A testamentary trust is a trust which is an entity. It's not a person. It's not even a thing. You can't touch it, but it's an entity which is set up. A testamentary trust is like last will and testament set up through the will, as opposed to, you may have heard of a living trust, or the proper name is inter vivos, while you're alive trust. And it's a difference of what's revocable, what's irrevocable. These are all issues which are well beyond the scope of a basic discussion, but they are important when you meet with your estate planning attorney to talk about what you want. Okay, some miscellaneous matters. If you have a bank safe deposit box, please close it. Now, having said that, if you have jewels or you have things which you don't feel comfortable keeping in your home, then I understand if you want to keep it, but don't put any of your documents in there, because even if you and a spouse or you and an adult child are co-signers on that box, chances are the institution, the financial institution, will not allow the survivor in to get the documents. It is much better to have a fire safe box in your home. Right now on Amazon or Walmart.com or a lot of other websites, you can get a fire safe box for the purpose of keeping your important documents at home for about $50. And it's delivered to your home. I strongly recommend you do that. If you want a link and you want to email me out, I'm happy to provide you with a link. Long-term care insurance, so important. If you have long-term care insurance, good for you. If you don't, if you're well, if you have the money to pay for it, go get it. I've had long-term care insurance for more than 20 years because I saw people around me who were getting sick and wouldn't qualify for it, excuse me. When you're sick, you can no longer get it. And people say, oh, long-term care insurance is expensive. Not really, because if you ever need it, it's a drop in the bucket. Here in Nassau County, if you need to go to an assisted living facility, you're looking at $6,000, $7,000 a month. If you need to go to a nursing home, it's $12,000, $13,000 a month, unless you're on Medicaid, which is another issue which we'll discuss. Long-term care insurance allows, number one, for you to have an aide in your home or to pay for assisted living. It does not require your spouse to give up his or her job or to take care of you 24 hours a day. I mean, it's a really important part of estate planning. If it's too late, okay, but if you're well and if you can afford it, I strongly suggest you look into it. You don't pay for it unless you qualify and move ahead. Life insurance. So I like term life insurance. Some people like whole. I understand that, but I like term life insurance. In my opinion, as an attorney, the only time you really need insurance is if there are people who are dependent upon you. That if, God forbid, Zahava Schechter died, who would pay for my minor children? I don't have minor children at this point, but if I did, who would help them? Who would pay for their daily needs and college and all of those other things? So that's an important conversation to have. And obviously disability insurance, if you're working and then you become disabled and can no longer work, how are you going to pay for your daily needs? Medicaid planning. Everybody calls me. A lot of people call me and say, I want to keep my house, I want to keep all my bank accounts, and I want to go on Medicaid. Impossible. Medicaid, let's talk about Medicaid versus Medicare for a moment. Medicare is age-based. If you're 65 years old and you're Bill Gates or Warren Buffett or name anyone who's very wealthy, you qualify for Medicare, just like if you were poor. At age 65, it's age-based, you qualify for Medicare. Medicaid is financially based. You could be 1 day old and qualify for Medicaid. Medicaid has nothing to do with how old you are. It has to do with if you're poor. So if you want to qualify for Medicaid, and there are many ways to do it, and you can transfer assets out of your name and not have money and not have control, because that's really what it's about, giving up control of all your assets, which many of us don't want to do, then maybe you can qualify for Medicaid. But don't think that, oh, I'm going to keep my house, I'm going to keep my bank accounts. I get $5,000 a month from my IRA, from my required minimum distributions, from my pension, all that, and I'm also going to qualify for Medicaid. No, we taxpayers, all of us, pay for Medicaid, and it is for poor people. Having said that, I'm not saying that if you have money, you don't qualify. Obviously, many people do. That is a discussion for another program. Gifting, you can give anyone and everyone up to this year $16,000. If you have a child, a grandchild, you don't have to pay tax on it. It's a way to see your money helping those you love, and there's no tax consequence to you. If there's a tax consequence to them, that's a different issue. I like to do my gifting in cash, but that's also for another discussion. Check beneficiary designations. This is absolutely crucial. If you walk away from this program with only one idea other than checking unclaimed funds, please let it be this one. Go and check every bank account, brokerage account, insurance policy you have, everything, IRA, 401k, 403b, everything you own. Make sure you have beneficiary designations. Why? Zahava Schechter has a bank account, and I named John Smith as my beneficiary. I died. We don't have to probate, meaning go through the courts, that account, because John Smith is going to take my death certificate and his ID and go into Chase, and he'll get my money right there. They'll give him a check or cash or whatever he wants right there on the spot. It's the best estate planning. And you know what? It costs you nothing, and you don't need a lawyer to do it. So you are the only one who can do it, of course. You go and do it. Now, let's say you have a joint account, you and your spouse, you and your child, whatever. Name beneficiaries in any case, because after the second one dies, there has to be a beneficiary so somebody can go and get it. Let's say you have 3 children and you want to say, my children, that's fine. That's good too. The point is, beneficiary designations are very important, both primary, who takes first, and if those people die, then who takes second. That's called contingent. The worst thing that can happen is either you don't have beneficiary designations on all those accounts and policies and everything we just discussed, or the person you've named is dead, or the person you named is someone you don't really like anymore. That person either will get it, that person you don't like, or it's going to force your will to be probated, or if you don't have a will, that's called intestate. It will force court intervention to determine who gets the money. It's going to take a long time to get it, and when they get it, and why they get it. So please go help yourself and do the beneficiary designations. Now, I do a lot of pre and post-nup agreements for second marriages and beyond. I actually do for quite a bit for first marriages, especially as people are getting married later, and they may have businesses and they may own their homes, etc. However, certainly, if you have a second marriage or later with separate children and you want your children to inherit, it's very important. Or if, let's say, you're very wealthy and your fiance is not, very important. Okay, deed transfers. I'm just including this. This really is a discussion, a very long discussion. But people call me and say, okay, the house is on my name. I want to now transfer it to my children, meaning it's me and my daughter and my son. It's not always a great idea from a tax perspective because of something called capital gains tax. The IRS has a provision that if you bought your house and it was $30,000 in Nassau County 50 years ago, and then you die and now it's worth, I don't know, New Hyde Park, let's see, 800,000. I don't know what the value of your house is. Let's say 800,000. Your family, your beneficiaries, I should say, will get what's called a step up in basis and will not have to pay any capital gains tax. That is not the case if you start transferring the property, meaning to yourself as well as your children while you're alive. This requires a longer discussion, but just be careful. Don't think that's not a panacea to start moving property around. Plus, you have to pay Nassau County about $1,000 just for the privilege of writing a new deed and filing it, and you have to pay a lawyer to prepare all the documents. So deed transfers are not always the way to go. Very quickly, wow, very quickly on a trust. A trust, as I said before, is an entity. Think of it like a circle, right? Now, there's nothing in that circle. So if it stays that way, that's a waste. You have to move things into the trust. And how do you do that? By transferring to a trustee. It is not always the best thing to do. Not everyone needs a trust. I used to listen to sometimes or hear about, trying to think of her name, it'll come to me in a moment, who used to say everyone needs a trust. Susie Orman, everyone needs a trust. No, not everybody needs a trust. There should be a reason, and we're going to talk about those reasons now. It's all about the control, whether losing control or having control. Governmental assistance. If one of your children or beneficiaries is currently on Medicaid and that person receives money and inheritance, it's going to knock them off Medicaid. That is not a good decision. So be very careful if any of your beneficiaries are currently receiving SSI, Medicaid, any other kind of governmental assistance. Medicaid planning, as I said before, Medicare and Medicaid are different. If you're doing Medicaid planning, you are going to divest yourself, lose control of all of your assets, because if you have money, you're not going to qualify for Medicaid, right? Spendthrift. Let's say you have, I'm going to pick a daughter, like Imelda Marcos, who likes lots of shoes. If you know someone who's going to spend money on a lot of, unnecessary things and not have any money left over, maybe you want a trust to control the frequency or the amount of money going to that person, so that that money will be there long term and not spent right away. Addiction. We all know people with alcohol addiction, drug addiction, opioid addiction, gambling addiction, right? Those people are going to spend money. They have $5 in their pocket. It's going to be spent right away. That's a good reason to create a trust. Ease of administration. I have clients who are very wealthy. They have assets in loads of places. They have the Florida home. They have the Hawaiian home. They have all these things. Everything goes into the trust. It's easier for their children and those they leave behind, or their spouse, etc. Ease of administration is really a great reason when you have a lot of assets, especially, not only, but especially if you're not sure if your family can handle it, or assets all over the place. Okay, be careful who you name as trustee. Choose that person wisely, because that person is going to have control over all your assets. May you be the grantor, the person who creates the trust, the trustee, the person who handles and manages the trust, and the beneficiary, the person who receives income from the trust. Absolutely. That's called a revocable trust. Revocable, can be changed. That is not a Medicaid trust. Okay. We're almost done. 2 quotations by Benjamin Franklin. In this world, nothing can be said to be certain except death and taxes. We're going to die anyway. I have people sometimes who say to me, I don't want to make a will. I don't want to do any planning because I don't want to think about death. Well, we're going to die anyway. So is it on your terms, or is the government going to tell, and a judge going to tell you what's going to happen, or not you, but your family, who can get your hard-earned money? And by failing to prepare, you are preparing to fail. May I suggest that it is a very good thing to do planning, because then you know that your wishes are being honored, not somebody else's, and no one is deciding, not the lawyer, not a judge, not New York State, the assembly, the representatives in Albany. You're the one who makes the decisions about your life and your death. So I strongly suggest that you make those decisions. If you have a question, I see there's something in the chat box. Feel free to either put it in, or you can contact me afterwards. Be well. Thank you so much for your attention, and I'm going to stop the recording right now.